Hello, everybody, and welcome to History Bite number 92, dated October 25th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled Trial Courts versus Appellate Courts. In our system, we have two distinct types of courts, trial courts and appellate courts. Both perform very distinct and non-overlapping functions. That is why it is very important not to confuse the two and to understand which functions are performed by which court. Many people who are unfamiliar with the system may confuse these operations, and the purpose of this video is to provide clarity so that you may understand the specific functions of trial courts versus appellate courts. We'll start with the trial courts. Trial courts, are where most litigation begins. Roughly 95% of it, in fact. Only about 5% of litigation is allowed to commence operations in an appellate court. Those are very rare instances. It hardly ever happens, but it can. Trials are almost always presided over by a single judge. And being that at the trial level, that is where most litigation begins. This is where witnesses are called. This is where evidence is presented. A trial, is a fact-finding forum. It is a truth-finding session, And in a civil trial, the purpose of the whole thing, is to prove an individual or corporation's liability, In a civil trial, usually one is seeking monetary damages, or other types of relief. But most of the time, it's monetary damages. In a criminal trial, the purpose is to prove the guilt, the alleged guilt of a defendant or defendants, A civil trial is initiated when one person files a civil complaint against another person or a corporation of sorts. In a criminal trial, that begins when the state files criminal charges against an individual or individuals or a corporation. I just use corporation to speak in general of businesses, Regardless of what type of trial it is, this is where the matter, an issue of fact, is determined once and for all, During the course of a trial, the judge will hear evidence and rule on the admissibility of said evidence presented. And once all of this is completed, if there is a jury present, the judge will give instructions to the jury with respect to what evidence can and cannot be considered for purposes of deliberation and reaching an ultimate verdict, regardless of whether or not it is a civil or criminal trial. If there is no jury present, the judge will make a determination of fact and law. If there is a jury present, the jury will certainly make the determination of fact, and the judge will make the determination of law and apply applicable laws to the case at hand, In certain instances, the jury may be able to impose sentences as well as award damages, There are always variances to the system, but this is what happens regardless of typically the state or locale individual. With trial courts, the process is very regimented, and typically, no matter where you go in the United States, most trial procedures are overwhelmingly uniform, Now, if in the event a decision is reached that the losing party feels that there was some sort of procedural error or misapplication of the law, they take an appeal to an appellate court, which we will now cover their functions. Appellate courts hear cases on appeal from the trial courts. Unlike trial courts, appellate courts are almost always presided over by at least 2 to 3 or more judges. Rarely, if ever, are appellate courts, or cases heard on appeal rather, heard by a singular judge. Unlike in the trial courts, appellate courts do not hear any new witnesses. They do not hear any new evidence. Okay. All of that, all the fact-finding process is considered done and essentially set in stone from the trial court. Okay. The appellate court does not address the issue of fact. Like I said, that is considered a done deal in the trial courts. All right. The appellate court only considers issues of law or procedure which the losing party has asserted were not applied or performed correctly at the trial level. All right. It is then up to the appellate court to make the determination based on the arguments presented by the attorneys, known as appellate advocates, whether or not the law was applied correctly and whether or not proper legal procedure was applied at the trial level. Now, if all of that checks out as being done correctly, then the appellate court will in all likelihood sustain the decision of the trial court, regardless of whether or not they personally agree with the outcome of the case. Okay? If the appellate court determines that some sort of misapplication of law occurred or some sort of procedure was not adhered to, according to the law or by existing precedents, all right, then the trial court will in all likelihood the appellate court will then in all likelihood reverse the decision of the trial court and order a new trial, what's known as a trial de novo, all right? It is not easy, however, to prove that law or procedure was not adhered properly in the trial court. If law and procedure was adhered to correctly, overwhelmingly, then in all likelihood, the trial court's decision will be left to stand. One thing I have learned in working for both lawyers and the judiciary in my former life is that judges do not tend to enjoy overturning each other. It's a respect thing. Okay. So assuming that everything even closely, went as it should have at the trial level, the appellate courts will be very, very, very cautious and hesitant, to even think about overturning the decision made at trial. All right. And typically, when decisions are reversed at the appellate level, it is as a result of a clear, beyond all discussion, misinterpretation of the law at the trial level, or a blatant and not even subtle disregard for accepted and required legal procedure at the trial level. Okay. Now, assuming this appellate court is not an appellate court of last resort, their decision, may be appealed further to an appellate court of last resort. That could be a state Supreme Court. That could be the United States Supreme Court. All right. And whatever determination the appellate court of last resort makes is final and conclusive. that appellate court of last resort may indeed overturn the lower appellate court, all right, and remand the matter for a new trial if the lower appellate court sustained the trial court's decision, okay? Or it may affirm the lower appellate court's decision in full, leaving whatever decision the trial court made in place. So that's all that. That's trial courts versus appellate courts, all right? Any questions or controversies? Leave them down below. I'll be happy to answer them. Take care, stay safe out there, and I'll talk to you at the next one. Peace.